So let's get to it. Today, I am smoking an Opus X. Opus X is the premier cigar line from Arturo Fuente's Fuente offshoot or division. And it's probably an understatement to say the Opus X line is among, if not the most popular cigar line in the world. They're often sold out online. It can be hard to find the different variations locally. But having said all that, I have only ever smoked one of these cigars in my life. And that was 2.5, 3 years ago. And I believe that was the Bellicoso, which just refers to the shape of the cigar. The Bellicoso has a kind of a rounded pyramid head, and it's a relatively shorter cigar. And I didn't love it. I didn't hate it, but I didn't love it. It wasn't remarkable or memorable. And I haven't smoked an Opus X since. But I was in the store the other day, and I was thinking to myself that maybe I had written off one of the world's, or maybe the world's, most sought-after cigar line. So here I am with an Opus X, and this one happens to be the Love Affair. That's the name of the cigar, the Love Affair. So if the Love Affair doesn't get it done, I don't know what is going to do it. The Love Affair is in perfecto shape. That refers to the shape, and it's a perfecto because it has a closed foot here at the end where you light, and its body tapers towards the head. This is a Puro. Actually, all of the Opus X line are Puro cigars, or pure cigars, which just means that all components of the cigar come from the same country. So there are three primary components to a cigar: the filler, which is the main tobacco inside the cigar, the main smoking element; the binder, which is the inner layer that holds the filler together; and then the wrapper, which you probably guessed, is the outer layer that holds everything together. And in this cigar, in this line, all of those elements come from the Dominican Republic. So, Puro. This is supposed to be a medium to full body cigar, so I like a strong cigar. We'll see if it holds up. And while I cut and light this bad boy, I'm going to talk about bail or bond. The only difference being bail is what you pay to a court in order to not sit in jail while you're proceeding, your case goes along its merry way. Bond is what you pay to a third party in order to not sit in a cell while your case goes along its merry way. And I'm specifically going to be talking about whether or not this question has come up on some cases I've been hired on over the last couple months post-conviction. This is criminal law we're talking about. The question of whether or not you can get bail or a bond once you've been sentenced to a term of incarceration. You're going to prison or you're sitting in jail pursuant to a jury verdict or a plea agreement. You've been sentenced. And the answer to that question is maybe. You may be able to get bail or bond. We're talking about a supersedeas bond or a bond pending appeal. So you've been sentenced and you intend to appeal some aspect of your case, whether it be some motion or motions that were filed during your proceedings, some aspect or aspects of the trial or the sentencing itself, whatever the case may be. You intend to file an appeal. An appeal will go to the appellate court. That is the court one level above the trial court. Trial court is where your case starts, where it's handled, it's initially disposed of. And the appellate courts review decisions by trial courts. They are a superior court. Under certain circumstances, they review. So you are going to take an appeal, and if you are going to take an appeal, you may be eligible for bond. And the way it works is, once you file your notice of appeal, Normally, that's how the appeal starts. Your attorney can then move or file a motion for a supersedeas bond pending appeal. One of the things your attorney will look at first is whether or not your charges are even eligible. There are certain charges that the state of Florida has determined are not eligible for supersedeas bond, much like your appearance bond, the bond you first got when you were first arrested, and that allowed you to not be in jail while your case proceeded. If your charges are not excluded by statute, then your attorney will file a motion for supersedeas bond and set it for hearing before the court. And then the court will make some determinations about whether or not it's going to grant your motion. And it's going to do so by looking at several factors. These factors come from rule and from case law. The seminal case is Younghans versus State. I'm going to put the relevant case citations in the description of the YouTube channel or somewhere on the YouTube channel. But it's Younghans versus State. And what Younghans and the rules state is that a court, you're eligible for supersedeas bond if your appeal is taken on good faith and the court finds that you are not a flight risk. Those are basically the two prongs that a court is going to look at. So starting first with whether or not your appeal is taken on good faith. So what the case law says is, and what the rule says is, good faith means the basis for your appeal is not frivolous, or more specifically, that it is fairly debatable. What does that mean? In a general sense, it means that the issue you are raising on appeal, reasonable minds can disagree about them, right? One reasonable person could see it one way, another could see it another way. And some of the boundaries that the court have set in determining what fairly debatable or the reasonableness of an issue are turn on things like it doesn't matter whether or not these issues have been raised before the trial court already. Most times when you're seeking a supersedeas bond, you've already tried to get a new trial. You filed a motion for new trial, it probably got denied, and it raised many of the same issues that you're probably going to argue on appeal. And even though that motion got denied, what the case law says is that's not determinative. It doesn't matter that the trial court has already spoke on those issues. What the trial court also says is the length of the sentence you've been given, even if it's really severe, that alone can be a basis for denying you a supersedeas bond. There has to be some other evidence in the record regarding your conduct and your past history with the case and with the law. And so Younghans lays out that it must be fairly debatable, and the court will also look to the second prong, whether or not you're a flight risk. And there are a number of factors to determine that. One of them, what has your conduct been like throughout the proceeding? Do you have a place to go to where you have strong ties to the community you're going to be living in? And generally, whether or not letting you go is going to be a risk to a court. It's not an exhaustive list, but the takeaway for today's video is this. That first consideration. What has your conduct been like up to that point, from the time you got arrested through the time that a court is determining whether or not you're going to get a supersedeas bond? If you are the type of defendant who has walked into court and taken every opportunity to curse the judge out, to show your ass to the judge, to get into arguments with the prosecution, to be late to court hearings that you're required to be at, that your attorney tells you need to be at, if you're that kind of defendant, you're going to have a very difficult time getting an appellate bond. The court is going to look at things like I just said, did you show up for hearings you were supposed to be at? Did you violate any terms of your appearance appearance bond, your pretrial release. All those things come to play later on. So the takeaway is how you conduct yourself throughout your case may come back to bite you later on. If things go sideways at trial, or if you're in a plea agreement, which may be in your best interest at the time, that involves a term of incarceration. So my advice to you is get a good, competent attorney to handle your criminal case and follow their directions. If they're telling you need to be somewhere, be there, and be on time, and be as respectful as you can, even when it feels like you're being railroaded. And it can feel like that a lot of the time. Not bad. Can't really tell anything from the first couple polls. But the way you conduct yourself is a determinative factor. So give your attorney something to work with. Supersedeas bond motions are difficult. Effectively, you are asking a judge to acknowledge that he or she may have made some errors at some point through the proceedings, at some point through the trial, at some point through the sentencing. That is a hard, they're human. Judges are human beings. And it can be hard to admit when you're wrong. And oftentimes, you need an attorney who understands how to make those arguments and make it in a way where a judge has a ledge they can step off of and grant your motion. Now, one of the things to remember when it comes to a motion for supersedeas bond is this: you get more than one bite of the apple. So I say this without having memorized the committee notes on the rules that govern supersedeas bonds, but if the trial court denies your motion for supersedeas bond, you can then file, your attorney can file what's called a motion for rehearing in your appellate case. And you can have the appellate court take a second look at the arguments that you have raised for a supersedeas bond. So in that regard, you get a second bite of the apple. But like I said, the takeaway here is follow your attorney's instructions. So God forbid you're in a situation where you need a supersedeas bond. You've done your best to make sure that it gets granted. All right.